There we go. Good morning, everybody. And I wanted to welcome you to this morning's cybersecurity mentorship webinar. We're going to talk a little bit about the law, legal proceedings, legal activities, things that you may run into or encounter as part of your cybersecurity job or even an IT job, to be honest. So just some things to think about. I'm going to, because we're talking legal stuff, let me go to the next slide. Because we're talking legal stuff, I have to advise you that I am not a lawyer. And therefore, what I am saying is not legal advice, blah, blah, blah. The reason I'm saying this is I'm protecting myself. So nobody's going to go out there and do something and say, well, my mentor told me to. Please don't do that. Anything that you do, use all of the things in your history as well as legal advice to make your decisions. Don't use what I stumbled across or what I define as being the law of the land. Good morning, Harminder. Good to have you. So we're talking about legal stuff, and I do want to let everybody know I'm not a lawyer. This is not legal advice, and blah, the usual disclaimers apply. Why? Because I want to protect myself from the law. Yes, it's that bad. So let's talk a little bit. Have you heard of EULAs? EULAs. Anybody know what EULAs stand for? Chris, you're probably extremely familiar with them.
I'm familiar, so I'll let the mentees answer.
Any ideas?
No, sir, I don't.
Okay, EULA is what it stands for, is what the actual acronym is, and it's an end user license agreement. Like when you're using you first get your Microsoft software or your Apple OS. Whenever you have an OS upgrade on your Apple software, you get this monstrous, and I mean it's like 18 pages long license agreement that says, blah, 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 you don't hold us responsible, blah, 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 we will not be responsible, blah, blah, those sorts of things. So that's one of them, and the other one I have here is the Logon warning banners. In other words, when you connect to a system or you're logging into a particular system, something can pop up there and it says, warning, please be aware, et cetera, et cetera. The main purpose of end user license agreements and logon warning messages are basically, anybody have any thoughts about why those are there?
For protection?
Absolutely. They protect both the provider of the service and the user of the service because they help lay out what things this does do and things this doesn't do, what you can expect in the way of treatment or confidentiality or privacy. We're going to talk about privacy a little bit later as well. But the main purpose that they serve is to help make sure that everybody understands what these things do and don't do and what you can and can't expect when you're using them. So let's arrive at a common conclusion. This has been my experience as well as my experience in prior CyberSecurity Sensei webinars that we've had. What is one overarching statement that we can all agree on about these end user license agreements and the logon warning messages? The thing that we can all agree, we don't read them.
Well, I was scared to say that because I thought you're supposed to.
You are.
That's what I was thinking.
You are. Absolutely you are. Because it lays out the rules of the road for you to use this particular operating system or piece of software or whatever. It's sort of like if any of you have ever flown to a foreign country and you want to rent a car at the airport and go driving, you know, let's say to Mexico, and you want to go check out the Mayan ruins or whatever, the first thing that they make you do is read the laws that are going to apply to you when you get behind the wheel and start driving. So yes, it's important for us to recognize that an end user license agreement is there for my protection as well as the protection of the people that are offering this particular service. So yes, it's important. Yes, they are monstrously large, and like in the case of Apple, they are obtusely big. Large to the point where it would take you 10 minutes to read it all. But what I do recommend you do is at least take a quick look at it before you click on that accept button down at the bottom, because it really does provide you with some understanding of what you can expect. Okay, so don't just pass it by. Don't just say, yeah, sure, whatever, and then later on get upset when stuff happens that you didn't expect or didn't happen that you did expect. The end user license agreements and the logon warning banners. Here's a good one where they say if you're logging into like public systems like on the federal government, it says there is no expectation of privacy. It says right there, you cannot and you should not expect that anything you do on this government system can be considered private. It says that right in those banners. What that means is the government has, and we're going to talk about this in another slide, the government has the right to examine what you're doing in reference to any legal investigations that are occurring. Doug mentioned this on Facebook. I don't know if you guys saw that this morning. The whole discussion about privacy came up because of those Facebook messages. If you guys saw the Facebook Messenger, by default, Facebook Messenger messages are not encrypted. What that means is, and this occurred, some state investigator subpoenaed Facebook records of conversations between a particular individual and other individuals and used it to arrest this person and take them to jail and try them for breaking state laws. Facebook messages. Okay, so be aware. So when Facebook says, yeah, we're going to encrypt it now by default, what that means is Facebook is trying to say, we are going to make it to where you and we can't read it afterwards. So that's the big thing that's going on. Facebook messenger messages can be used in a court of law, just like record of phone tapping. So be aware of that. Next one, customer legal rights. And of course I ask the silly question, do customers really have a right? You're in IT. Let's presume you're in IT by this point, and you have an IT job and you are doing work in a particular system or with particular things, and by virtue of the job that you have increased rights and privileges on a particular system. that sort of goes without saying. For example, for many years, I operated as a Microsoft Exchange email administrator. And it was possible in some cases for me to go in and look at my customers' emails. It was possible. Now, here's the big question. Did the customer have any rights? Well, here's the important thing for us to recognize, that customers do indeed have rights. And one of them is the right to privacy. Oh, let's go down the list here. There are such things, because the top two actually came straight out of my Security Plus study guide. So let's go to those two first. There are what are called legal holds or legislative holds. And that is the result of an official criminal investigation. It could be a civil investigation, by the way. And somebody who is a member of either the law enforcement community or the legal community contacts your company or your government agency and says, we are asking that you place a hold on the following information. And it says, you know, information between this date and this date, between this person and anyone they spoke to, or, you know, please preserve all phone records, preserve all document records, preserve all email records, etc. It's called a hold. And what that means is, legislatively, that information could be called upon and reviewed as part of an investigation and could be used in a court of law. So they say put a hold on it. Now, when you're working, what that means is you must make sure that it doesn't get deleted. You must make sure that it does get preserved. You must ensure that people don't go looking at it. You know, I will give a good example. There was a period of time, and for those of you who are older like me, you remember a name of Monica Lewinsky. Monica Lewinsky was a White House intern, and there were lots of legal things that occurred in reference to and related to not only her herself, but other people that were involved in the legal affairs, including President Bill Clinton, and people that Monica spoke to, and people that Monica emailed. And the reason I say that is her friend and somebody she confided in worked over at the Department of Defense. And yes, the DoD emails from this person were placed on legal holds so that they could be discussed and possibly brought up in a court of law. Emails from somebody who was not the complainant or the respondent. It was just somebody else. Why? Because what you say and do, what other people say and do on your systems can be used in a court of law and can be used as part of a legal investigation. So a hold means you must preserve it. If you have, let's say, every week we flush all of our security logs, well, guess what? If a legislative hold has taken place, you have to stop that weekly flushing of your security logs, those sorts of things. Okay? Any questions about legal holds?
I've never heard it that clearly put, and I do appreciate that. Now I kind of understand in my capacity what that actually means. Thank you.
Yeah, you're actually sort of like the water carrier for water that somebody could later on say, well, this is part of an investigation. So your role is to make sure that, for example, nobody inserts wrong emails, nobody deletes emails, etc. So that's your part in this. Chain of custody. Has anybody ever heard of a chain of custody?
No, sir, I haven't.
Okay. In what's called the rules of evidence, I'm using big words, but in the rules of evidence, they basically say in order for something to be admissible in court as like a an example or a, what do they call it, evidence, exhibits of evidence or whatever, they have to say we can prove that this is what it says it is or what it looks like. You know, I'm going to use a really weird example. Here's a pen, and you can say, well, you know, is this the pen you used? And then somebody can sit up on the stand and go, well, it resembles a pen I used, but I can't say it was the pen I used. What's called the chain of custody says the investigator took this pen off of your desk and placed it into an evidence bag, signed the evidence bag, and then from then on, this person transferred it to this person who signed the evidence bag, and this person transferred it to this person who signed the evidence bag. That's why you see in all these legal shows and stuff, there's this guy behind that big, you know, box with all the bars and stuff, and they say, hey, I want to see the revolver that was used in that crime or whatever. That's called the rules of evidence. Whenever something changes hands, chain of custody means the new person must sign for it, and you must be able to read who signed for it and agrees to preserve the rules of evidence. So you can say, was this your pen? They say, gee, I don't know, it looks like my pen. Well, the rules of evidence and the chain of custody proves that this is indeed the pen that was on your desk, and by the way, here are your fingerprints on this pen, you know, or from the crime scene or whatever. So the chain of custody also applies for things like IT information, like emails. Remember, we talk about the confidentiality, integrity, and availability of information. That's when it comes down to the legal affairs, you have the chain of custody where stuff, you know, can or cannot be proven to be from a particular person. And we'll discuss that in my war story, because that is what caused something to not occur. And then admissibility means that something has been preserved enough to the point where it can be admissible in a court of law. Okay? Any questions before we move on?
Okay.
Okay. Good. So here are, I'm going to talk the big one, the big war story that I had. And the question is, did that actually happen? Well, I will neither confirm nor deny that it occurred, because, you know, in the period of time that things have occurred, you know, maybe my memory isn't correct. Maybe my memory, you know, this was just a bad pizza I had the night before or whatever. But this is my recollection of what happened. Okay? So I was working, I'm serious, I was working for the Secretary of Defense. And at this point, it was Donald Rumsfeld, and he was in the Pentagon as the chief of the Department of Defense. And he is allowed to hire and bring in what are called special assistants. And therefore, certain things like, you know, well, what about the Navy tailhook scandal or whatever, you know, something that occurs that this individual really needs somebody who was there. The Iran-Iraq war, or the Gulf War, or, you know, any of those sorts of things. They can bring in what are called special assistants and pay them on the government payroll to be able to grab them and have them run down the hall and talk to him, for example. Well, there was a particular special assistant who was a retired 3-star military officer that was now working for a major, defense contractor. And this guy was hired as a special assistant, had his own office, big office in the Pentagon. And he was a real high roller, and he wanted stuff, and he wanted stuff now. And he actually did a lot of work for the Secretary of Defense, and he used a laptop a lot from his house and from probably other places. Well, he kept complaining that his laptop was slow, and the connections were slow and things weren't working well, and etc. So they called the help desk, and I responded. And I went into this guy's office, and he said, "Hey, my laptop's not working right. Can you make it work faster?" And I said, "I'll give it a look." So I walked down to my office with his laptop and started to do things like, clearing cache and making sure that all the memory tested out well and those sorts of things. And as I was going through this guy's hard drive and clearing the cache, guess what I discovered? Well, I reportedly discovered. I seem to recall that I discovered child pornography on this individual's Department of Defense official government laptop. Here's the thing. There was no chain of custody. When I discovered it, I can tell you I was sitting on a chair with wheels, because the first thing I did, the moment this popped up on my screen, I shoved myself away from the laptop and held my hands up really high and went, "Boss," and called my supervisor over, because I was in the middle of the help desk area. I went, bam, and pushed myself away from that laptop as quick as I could and called my boss. And she and I, both sort of stood there looking at this. And what she did is she called what was called the Air Force Office of Special Investigations, AFOSI. And a couple guys in suits came down and sort of took a look at it and said, "Okay, thank you," picked it up, gave my boss a receipt, and walked away. So, of course, the first thing you think of is, what happened to this man? Well, a few weeks later, he was no longer the special assistant for the secretary. But what did not occur is we never heard anything about him getting in trouble. He went back to his firm, spent numerous years there, and I'm sure he retired fat, dumb, and happy. Why? Because there was no legal proof that would hold up in a court of law that that information that was on that laptop had been placed there by he himself. It could have been me. It could have been somebody else. It could have been somebody who came into his office. There were times where he had the laptop sitting all by itself at home. There were times he had the laptop sitting all by itself at work, etc., etc. There was no chain of custody. So that junk that was on this guy's laptop was never used in a court of law against him. So for you speaking, yeah, Harminder, go ahead. I can't hear you. Unmute your microphone. Still don't hear you.
Hello?
There
now,
you are. Go ahead. Yeah.
Okay. So 1 second. Okay. So yes, so I have a question.
Sure.
I know I heard everything what you are explaining. Mm-hmm. When the person using the laptop, he have their own credentials. he have their own credential. Without his own credential, nobody, maybe he have a loaner laptop, or without any credential, nobody can do anything, any laptop. Okay, how you say we did not prove anything what who do it, and so what we can do in this situation?
I'm not disagreeing with what you said, Harminder, but remember that this, I'm reminding myself of this. This was back in the days when these laptops were running Windows 98.
Okay.
And therefore, that was a client operating system. And that system, although it did log in to an enterprise and used Active Directory, and therefore, like you were saying, there were credentials associated with it, this was browser cache on the hard drive, which is not segregated by profiles. It's just specific to that particular browser. So it could not be traced directly to that individual. He had been out browsing, and anybody that used that laptop could have put that stuff there. It was browser cache.
I got it.
Now, these days, all of your browser cache stuff is kept specific to your user profile. And therefore, as you're saying today, it's a little bit easier to draw that line of whose information is this. But then you also have to go back and say, was this person the only person who could have logged on with your user ID and password and gotten this information onto this laptop? That also has to be proven beyond a shadow of a doubt. And if, for example, you put your password on the bottom of your keyboard, there's no more proof. What if somebody else knows about it? What if your kids knew about it? There's no more proof. It will not stand up in a court of law. You've heard the discussion about what it takes to obtain a conviction in a court of law. And by the way, that's my next slide. A conviction in a court of law requires proof beyond reasonable doubt. And what the defense attorney's job is to insert reasonable doubt. So if you think about it, you're trying to prove something occurred without a doubt, and the defense attorney is trying to say, well, there is doubt. No doubt, yes, there is. No doubt, yes, there is. And the jury has to make that decision. Was this proven beyond doubt, or is there really a doubt that this could have occurred this way? And reasonable doubt is the word they use. Why? Because you could say, well, the Martians came down and put this on my hard drive. Yeah, right. President Lincoln arose from the grave and put this on my hard drive. Whatever. Reasonable doubt. It's much easier to say, I left it. I lost it at a nightclub, and it showed up, the next day. Somebody could have logged into it. Those sorts of things. Make sense? Okay, I don't hear you. Okay, yes. All right. So,
yes, that makes sense.
So anyway, that was my war story. I wanted to sort of point that out to you guys. You could be involved in a legal investigation, and therefore you need to know that, for example, if you are contacted by a member of law enforcement, you must do what they tell you to do. Okay? However, if you're contacted, let's say, this has occurred as well, somebody's manager contacts you, walks into your office and says, I want to see John Doe's emails from last week. Email is protected by privacy laws. Even if there's that big monstrous warning banner that says there's no expectation of privacy, blah, 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 blah. Okay, there are proper ways to request and to divulge information. And somebody's boss walking into your office and demanding to see their email is not one of them. All right? So at that point, if you were involved in something like that and somebody comes down, I don't care if it's the CEO of the company, you need to say, let me get somebody who can speak in terms of legal, my rights and privileges as a part of this investigation. If you were let's say a regular IT person, now would be when you would call your union rep. And if it got real serious, you'd call an attorney. Because you could very well end up standing in court, do you solemnly swear to tell the truth, blah, 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 blah. This is how it happened. You could. Even as an IT person. So make sure you dot your I's and cross your T's, as they say. Email, again, is protected by privacy laws. Your boss, you yourself, the president of the company, whatever, cannot demand that you take part in pulling up somebody's email and reading it. An investigator in an open law enforcement investigation can, but your boss can't. And I've run into those situations where somebody has literally told me, you have to do this, and I've said, I'm sorry, I can't. Because if you read those big monstrous Logon warning banners, it says, if in the course of an official law enforcement investigation or criminal investigation, you are asked by law enforcement personnel to give this information up, you must do so. That's different than your boss walks into the office and says, open up Tommy's emails from last Tuesday. Okay? Here's where you must ask yourself, number one, can I do this? And for most of us, technically, the answer could be yes. But then the next question you must ask is, should I do this? And thirdly, must I do this? All right? Just because you can doesn't mean that you are legally allowed to or legally obligated to. All right? Harminder, go ahead.
Okay. This is only implement to the state or federal government, or this is implement to everybody? For example, my brother, sister, my colleague. Is I am able to read the email, or it is only a confidential, only privacy? And so that's I just want to.
Very good question. You need to look at the license agreements and the Logon warning banners for the company you work for. But I will tell you, I've gone nose to nose with people who say things like, I can ruin you, and I've said my legal obligation begins when a member of law enforcement asks me to do this. So just be aware, just because you can does not mean you should.
Scotty, challenge question for you. What if it's your direct supervisor who tells you?
Doesn't matter.
Does not matter.
Does not matter. Your and oh, by the way, your supervisor is supposed to know this stuff as well. If you're in doubt, here's what you do. You momentarily excuse yourself and say, I got to go run to the bathroom or something, and make a call to the Inspector General and say, hey, I'm being asked to do this. I'm in a position where this is going on. You know, are they allowed to ask me to do this? The Inspector General, in my experience, the Inspector General has been completely and thoroughly uninvolved in all of these things, and therefore remains an objective evaluator of your situation. Your union rep is going to say, no, don't do it, but the Inspector General could say, you know, well, let me come down and take a look, or whatever. But again, law enforcement, if it's an open case, and let's say somebody walks in and says, I need emails from blah, 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 blah. You say, can I see the case number? I need to write this down.
Can a legal ethical office be helpful as well?
They may be able to, but remember that, well, I'll give an example where we're at. In the federal government, the lawyers aren't there to protect the employees. The lawyers are there to protect the rights and privileges of the federal government.
Interesting.
Okay, so not every lawyer will deal you a straight hand of cards. Let me just say that. Because it's not their expertise, and they should know that. But if it's your cousin Kenny that you get on the phone, and Kenny happens to do patent and trademark law, and you're talking about something else, it may not apply. They may not be able to help you and provide you adequate legal advice in that particular situation. The Inspector General can always be able to, at the very least, document that you asked about it. So I have no qualms about calling the IG. The IG is about as fair and balanced as anybody can be, especially when it gets heated, like it's your boss screaming at your desk, screaming at you. Because guess what? If it really is something and you call the IG, you become protected by what are called whistleblower laws. So your boss, even if your boss got mad at you and said, well, you delayed this unnecessarily and therefore I couldn't, bring a case against this guy or whatever, so, you're on my bad boy list. Well, whistleblower protections means that you have rights as well. Even though you can, the question is, should you? And if you don't know, ask somebody who can tell you legally, should you. Okay. Any last minutes before we get to this last screen that we have here on the last slide?
I just had one question about reading those banners and those long. Do they change? Like once I read them in that capacity, would I need to read it consistently or periodically or once a year or something like that they change? Because once you read it, you know what it says, so you can bypass it.
Right. Very, very good question. A logon warning banner, for example, at our employer occurs every time you log in. An end user license agreement will pop up any time you have a major version change in your software, like if it goes from version 14.9 to version 15.0, the end user license agreement will pop up. What that means is things have changed enough so that you might benefit by reviewing this again.
Good. Understood. Very good. Thank you.
And I'll give another one of my goofy little war stories. I was with a particular government agency, and they were designing a brand new Windows 10 laptop. And they said, this is what everybody's going to use. And they plugged in this end user logon screen, the big blue screen that everybody gets. Well, this screen, guess what? Scotty had the forethought to go take a look at it. And it was full of misspellings. It had partial sentences. It referred to a manual that didn't exist, etc., etc. And I went back to the engineers who were putting together this thing, and I said, where'd you get this agreement? And they said, oh, security gave it to us. I said, oh, that doesn't look like something that would come from security. And the engineer's like, well, I don't care. Security gave it to us, so that's what I'm putting in. And for almost a year in my federal government agency, we had this misshapen, misrepresented mess up of a logon screen because the engineer said, I got it from security. Well, finally, when they were getting ready to give this to everybody, including the U.S. cabinet level post that was going to be, using this every day, I raised my hand. I have nothing to do with this. I was help desk at the time, but I raised my hand and I said, guys, read this screen. And the engineer's like, it doesn't matter. I got this from security. So I called around to everyone in security. There were like 8 different people that were involved in this from security. And I said, did you give it to him? Nope. Did you give it to him? Nope. And went through everybody. And finally I went back to engineering and I said, look, nobody in security gave this to you. And the guy's like, yeah, they did. Who? I don't remember. Well, no, they didn't. Yeah, they did. No, they didn't. It's wrong. So seriously, this is what occurred. They put in a change request to change that logon warning banner. And you know what the justification for the change request was? The justification said, Scott Ward said that this should be changed.
Oh my gosh!
Yeah.
No way.
Yes. Yes. And I'm like, you guys just don't get this, do you? So I pulled one that was actually from our security manual, word for word, directly out of a security manual as a recommended logon warning. And I said, why don't we use this? Because it's already approved and it's in our security manual. But yeah, the change request said, Scott Ward says we should change this. And I'm like, oh, whatever.
I mean, couldn't they tell that it's not just what you're saying, but what is actually in the context?
Nobody bothered to read it. And the engineer swore up and down that he got it from security, even though I went to security and proved him wrong. Oh, by the way, that engineer doesn't work for this federal government agency anymore. So anyway, just something to think about. My last war story for a moment. Okay, so here's something that you need to understand. There are at least 2 different types of courts in America. One is called a criminal court and one is called a civil court. Does everyone understand that those are not the same?
Yes, sir.
What's the difference?
One is like when the individual people are suing each other for personal, and and that's civil. Because you can sue if you can sue in both things for the same reason.
Mm-hmm.
But if one is civil for personal suits against the individual, and then the other one has more legalities to it. And that's my understanding.
Very, very good definition. You are right. A criminal court of law means that someone is being accused of violating a law or legislation. A law has been broken, and somebody goes to court to prove that the law has been broken. In order to arrive at what's called a conviction, and I already told you, we discussed it a minute ago, what has to be proven? You have to prove beyond reasonable doubt, right? That this individual broke this law. Okay? And you use evidence, you use witnesses, the whole 9 yards, and in some cases you use the individual who said it. By the way, you've seen all those cops shows where the guys are sitting in the back of the police car with their handcuffs on saying, yeah, well, I didn't think it was going to be such a big deal or whatever. Well, guess what? All of that is admissible in court. Every defense lawyer that you ever get says, first of all, pretend you're on cops and shut up. Because it could be admissible. So don't talk. What does it say? When they read you your Miranda rights, what do they say?
They tell you that it can be used.
Come on, you guys all remember, you've heard your Miranda rights a million times on TV shows. You have the right to remain silent. You have the right to an attorney being present with you. And anything that you say can, no. You said it the way a lot of people hear it. It says in your Miranda rights, everything that you say can and will be used against you in a court of law.
Wow,
think about it this way. Even if you think you're 100% right, 100% innocent, it doesn't matter. Anything you say can and will be used against you in a court of law. They are not your friends standing there offering you a popsicle or a bottle of water or whatever. Hey man, that was a real rough run we had, wasn't it? You know, running through people's backyards and, you know, as you were escaping the crime. No. I'd like to talk to a lawyer, you know, etc. So just be aware that the police are good at interrogation. And anything you say can and will be used against you in a court of law. So have an attorney present. Okay? So a conviction means that they have proven beyond a reasonable doubt. That's in a court of law. Now, what's a judgment in a civil court when they arrive at a judgment? What is that based on? Does anybody have an idea?
Is that when a judge makes a decision based on the evidence?
You're absolutely right, but there's a big word in there that you have to think about. It's called a preponderance of evidence. In other words, if there is more evidence for something as compared to the evidence against something, you can still arrive at a judgment in a civil court. So, for example, there have been numerous trials where someone was tried for, let's say, murder. And they went all the way through the trial and they were acquitted of murder. And then the next thing that happened was the family of the individual that was murdered brings a civil lawsuit against someone, and that person ends up getting a judgment against them, and the other people, the family of the person who was killed, ends up getting millions of dollars because the preponderance of evidence is much lower than proof beyond reasonable doubt.
Wow.
So you hear this a lot where somebody was acquitted in a criminal court, but then sued successfully in a civil court for what you think is the exact same thing. So the amount...
Properly, that word again is preponderance?
Preponderance. Yeah, preponderance of evidence. Think about it this way. 51% for, 49% against could still result in a judgment.
Gotcha. Got it.
Okay? So, and oh, by the way, just because you are acquitted from in a court of law, you're acquitted of a crime, that does not mean, for example, here's the big one that they do. They say, this police officer, and I'll use that as an example, not because I'm trying to make an example of the police, but police officer was acquitted of killing a particular person. But then the family of the victim sued the police officer and the city that the policeman worked for and accuses them of removing this person's civil rights by killing him. And this person's, one of their civil rights is life.
Whoa.
All they have to prove is that this person pulled the trigger on the gun that shot the bullet that caused this person to die. That's all they have to prove. Think about it. Beyond a reasonable doubt is for criminal. Preponderance of evidence is for civil. And they are not the same. So, just wanted you to know that. Hopefully none of you will ever be involved in this, but it can happen. Like I said, I was an IT guy sitting in the Pentagon, may or may not have happened, but I was an IT guy sitting in the Pentagon trying to help this guy with his laptop, and next thing I know, I'm sitting in the middle of a legal issue that has people in suits standing around our office talking to each other and looking at me. Okay? It can occur. So, play it safe. When in doubt, what do? Call a lawyer. Or call the Inspector General. Or call your union rep. Yeah. The IG is probably the most balanced. Your union rep is there on your side. The IG is not on anybody's side. Okay?
Got it.
So whenever you walk past that sign that's in the hallway of your office that has all of those legal notices, you might look up the IG phone number and just remember that it's there. Okay? Anybody have any questions? Comments? Did you enjoy this?
I really enjoy this. I always enjoy it. That's why I'm going to keep coming back.
Well, thank you.
I love it.
Chris, Harminder, you guys have anything?
Nope, really good, Scotty.
Thank you very much. Thank you very much, Scotty. It is a really, really knowledgeable and helpful topic. I know I never read all these agreement type because it is too long, but now in future I have to keep eyes on there. Yeah, too long. I just, we
Yeah.
don't have time to read all these and everything. When I
Yeah.
use a library computer, when I use any computer in a hotel, they have all kind of agreement. Because we are not, I'm talking about myself. I am not doing the wrong thing, but it is good to read all the agreements and everything for
Oh,
our.
right. Here's just something to think about when you're watching all those goofy medical commercials for this new shot that we've got or this new pill that we've got or whatever, and it says ask your doctor about blah 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 blah, and then they have half of the commercial is, you know, serious side effects such as blah blah
Right.
blah 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 have occurred. Do you know why they do that? They don't do that to inform you. They do that to protect themselves in case it happens to you and you decide to sue them, and they can say, listen, we told you.
Told you. Yep.
And they can prove it. Okay? So when they say things, serious side effects such as death have occurred. Well, guess what? You have been warned about taking that pill. Yep, absolutely. My wife is an example of that. She was prescribed something by the doctor, and she got it home, and she read all the possible side effects and warnings, and she said, I'm not taking this. I'm not taking this. We've got the med up in the closet. And she still, is not feeling better, but she's not taking this med. And I'm like, more power to you, baby. That,
To be worse for her.
There you go.
Even though the doctor said, this is supposed to do something that might be advantageous, but it does counter something else.
Yep. Serious side effects such as death have occurred. Maybe I don't want to die from this new cold pill. Anyway, hope you all have a good Saturday. I had fun doing this. If you have any ideas for topics or suggestions, please bring them up. I love to do this investigation and stuff. And again, we all get smarter as a result. Okay?
Yes. Thanks
so
everybody.
Much.
Thanks,
have
everybody.
a wonderful Saturday.